Good morning, all. Thank you for joining. This is the final rounds, but I'm being informed there are some judges who've not yet logged in. So kindly, please bear with us. And we are asking for an extension of 15 minutes to enable the judges join us. Thank you. Good morning once again. Thank you all for joining. This is Akmcc, the final rounds. My name is Rispa Odanga. I will be your bailiff for this session. And in this session, the participants are team 809 and team 805. And the bench comprises of Lady Justice Kosi Bor, who is the Justice of the Environment and Lands Court, who will be the presiding judge in this session. And other members of the bench are Mr. Victor Kamau, Ms. Aki Nasanga, Mr. Wangila Waliaula, and also Ms. Wamoyo Nderitu. Participants, all the best. Kindly, I'll be posting the time on the chat, so please be very keen on that. And at this juncture, I would like to hand it over to the presiding judge, Lady Justice Kosi Bor. Welcome. Thank you.
Good morning, ladies and gentlemen.
Good morning.
Good morning once more, ladies and gentlemen.
Morning.
The bench welcomes teams 805 and 809 to the hearing of Constitutional Petition number 1 of 2020 between Umma Human Rights Commission, the petitioner, and the respondents are the Attorney General, the Minister of Lands and Physical Planning, and the Minister of Transport and Infrastructure. My name is Kosi Bor, the presiding judge. I will ask my fellow judges to introduce themselves.
Good morning, everyone. My name is Nasanga Aki. Welcome.
The other members of the bench, please.
Good morning, everyone. My name is Wamoyo Nderitu. Welcome.
We have two more members of the bench. Raphael Gitau.
I am not a member of the bench, I am a participant.
Oh, I'm sorry, where are the other members of the bench? I thought we were 5.
Yes, Mr. Wangila, kindly unmute your microphone. And the other member is Mr. Victor Kamau, but he will be joining us as we proceed.
I've already introduced myself, I hope so.
Okay, thank you very much. Do you, the students of team code 805 and 809, appearing before this bench, solemnly promise that you will abide by the rules of the virtual oral pleading of the All Kenyan Moot Court competition, and that you will not communicate with or accept assistance from, in any way, your coaches or any other individuals during the oral pleading?
I do.
I do.
Yes, I do.
Yes, I do.
I wish to remind you that failure to comply with the rules, or in the event that you accept help from outside sources, including your coaches, it may result in the bench recommending your disqualification to the steering committee. May I now request each lead counsel to introduce members of their team?
Thank you, members of the bench. Good morning. My name is Raphael Gitau, first counsel appearing on behalf of the petitioners in this case. I am accompanied by Ms. Gladys Anyangweso, my co-counsel. This case concerns the alleged violation of the principle of due process of law in the eviction process that occurred on 20th June 2019, the alleged violations of the rights to adequate housing and access to justice, as provided for in Articles 43 and 48 of the Constitution of UMA. It involves the eviction process or the events surrounding the eviction process that occurred in the Msoto area in June of 2019. The petitioners in this case are represented by the UMA Human Rights Commission, while the respondents are represented by the Attorney General, the Minister for Lands and Physical Planning, and the Minister for Transport and Infrastructure. Of the 30 minutes that this court has so graciously donated to us, I will take the first 15 minutes to address the issues of jurisdiction, as well as the second issue in contention concerning the due process of law, while my co-counsel will equally take 15 minutes to address the first and third issues regarding the right to adequate housing and the rights to access to justice. We will make rebuttals based on the 3 minutes that have been availed to us by the court. Over the course of our submissions, we will be making reference to the Constitution of UMA, various acts of parliament, including the Land Act, the Public Order Act, and the National Police Service Act. We will also be making references to the international treaties and conventions that UMA has ratified, including the International Covenant of Economic, Social, and Cultural Rights. We will also be making reference to the jurisprudence of the courts of UMA and such other relevant jurisdictions. Thank you. I will now cede the floor to the opposing counsel to make introductions.
Sorry, sir, but which team was that?
Team 809, acting as the petitioners.
Thank
my
you.
lady.
Yes, thank you.
Madam President, Your Honors, my name is Vera Cherotich. This is Team 805. I'm the lead counsel as we represent the respondents. My co-counsel in this matter is Laura Otieno. In the 30 minutes time accorded to us by this court, we will address the issues of jurisdiction and admissibility. The first issue where we seek to demonstrate before this court that the government did not fail to adhere to court orders, therefore did not violate the right to access to justice of Msoto residents. The second issue where we equally seek to demonstrate before this court that the government in carrying out the said demolitions followed the due process of law. My co-counsel will then address the third issue, seeking to demonstrate before this court that the government also did not violate the right to adequate and accessible housing of the Msoto residents pursuant to Article 43(1)(b) of the Constitution of UMA. I shall use the first 20 minutes to address the court on the aforesaid issues, and my co-counsel shall use the remaining 10 minutes to address the court on the third issue. We reserve 3 minutes offered to us by this court to offer our rebuttals at the tail end of the presentation. Thank you, Your Honors.
Thank you very much.
Thank you, my lady. Before I delve into the issues of merit in this case, it is important for the petitioners to dispel any doubts as to the jurisdiction of this court to hear and determine these matters, and I will do so on 2 grounds. Firstly, that the Environment and Land Court does not have the jurisdiction to hear and determine this matter. And secondly, that this suit is not barred by the doctrine of res judicata. On to the first ground of my submissions. And it is the petitioner's averment that while Section 13 of the Environment and Land Court Act establishes the jurisdiction of the Environment and Land Court to include any and all disputes relating to land, it is not the petitioner's assertion that the Msoto residents have any proprietary interests in the land, nor do they assert that the evictions were not necessary. The petitioners seek to simply challenge the manner in which the evictions were carried out in asserting the rights of the petitioners to adequate housing, access to justice, and fair administrative action, the determination of which falls under the jurisdiction of the High Court by virtue of Articles 23 and 165 of the Constitution of UMA. Or to the second ground concerning the doctrine of res judicata. It is equally the petitioner's submission that the doctrine of res judicata does not apply in this case, regardless of the facts in paragraph 8, paragraph 22, and paragraph 23 of the fact sheet, where it is shown that there was a previous trial in which the UHRC filed a suit against the government on the denial of access to justice, police brutality, as well as the preferential treatment accorded to the Msoto residents. While the doctrine of res judicata was provided for in the Court of Appeal case of John Florence Maritime Services versus the CS for Transport and Infrastructure and 3 others reported in 2014 to include the following elements. And one of those elements is that the case must have been heard and ultimately decided in this case. The court elaborated on this by stating that the court must have exercised its judicial mind over all of the issues. As has been shown in paragraph 22 of the fact sheet, the issues for determination included the denial of the access to justice, the police brutality, as well as the preferential treatment accorded to the Masponyo residents. In the ruling, the judge gave a summary ruling or a summary judgment stating that the government had compelling reasons to demolish the properties due to public interest, which is not an issue in dispute in this case. What is in dispute are some of the issues for determinations that were in that case, yet were not addressed by the court. Now, I will now proceed on to the issues of merit, and I will be presenting on the second issue for determination concerning the due process of law. It is the petitioner's assertion that the respondents did in fact violate the principle of due process of law in the eviction process that occurred on 20th June 2019. In asserting this claim, the petitioners will seek to prove that 3 essential elements of due process were not adhered to by the government in effecting the eviction of the Msoto residents. Firstly, the requirement of adequate prior notice was not adhered to. Secondly, the requirement of formal identification of the persons conducting the evictions was not adhered to. And ultimately, that the requirement of necessity and proportionality as to the use of force was not adhered to. On to the first limb of my argument concerning adequate prior notice. It is the petitioner's assertion that the respondents did not grant the Msoto residents adequate prior notice before conducting the evictions that occurred on the material day. The High Court, in the case of Kefa Omondi Onjuro versus the Attorney General, reported in 2015, established that there is a requirement when a person is affected by an eviction process, there is a requirement that that person should be given adequate prior notice. Section 152C of the Land Act 2012, establishes the test for adequacy of prior notice. It establishes that notice should be effected through a newspaper of nationwide circulation at least 90 days before the evictions take place. Furthermore, in the High Court cases of Ibrahim Sangor Osman versus the Minister for Provincial Administration and Internal Security reported in 2011, as well as the case of Susan Waithera Karaoke versus the Town Clerk Nairobi City Council reported in 2012, amongst other cases within the jurisprudence of UMA, it has always been unanimous that when the persons have been residing in the properties from which they have been evicted from for an extended period of time and have depended on that place for their employment and their schooling and their enjoyment of social amenities, then it is unreasonable and unconscionable to give them only a few days' notice within which to vacate from the area. As has been shown in the fact sheet, Firstly, in paragraph 4 of the record, it shows that the Msoto residents were given 11 days. But to top it off, in paragraph 11 of the fact sheet, on the 17th of June, the government of Msoto went ahead to state that the demolitions would not take place until an amicable compensation scheme had been arrived at. From the 17th to the 20th, until the day when the evictions were carried out, an amicable compensation scheme had not been arrived at, and the minister had not made an announcement on the resumption of the demolition activities. Therefore, for all intents and purposes, on the 20th of June, when the ARPU agents descended on the Msoto area, they did not have any the Msoto residents did not have any notice of the eviction process that was about to take place, and therefore the government did not grant them adequate prior notice. Which brings me to the second limb of my argument concerning formal identification. It is the petitioner's averment that the respondents did not formally identify themselves in the eviction process that occurred on 20th June 2019. Section 152C of the 152G of the Land Act rather establishes that formal identification of the persons who are responsible for the evictions is a mandatory procedure that should be adhered to by anyone seeking to conduct evictions. As has been stated also in the case of John Mageto Nyachieyo versus John Kinyu, reported in 2016 at the Environment and Land Court of Nakuru. Section 152G of the Land Act establishes the mandatory procedures for evictions. These procedures are non-derogable and cannot be eschewed by the government under any circumstances. To establish formal identification, it is important to look at the Land Act Regulations 2017. In Regulation 66, which provides the manner in which the people who are conducting evictions should identify themselves. In the case of public land, there should be a letter from the National Land Commission accompanying the persons who are effecting the evictions. And in this case, as has been shown in paragraph 15 of the fact sheet, there is no indication that the ARPU agents brought with them the letter that I authorized them to conduct the evictions that took place on the material day. Which brings me to the third limb of my argument concerning the requirement of necessity and proportionality in the use of force. It is equally the petitioner's assertion that the respondents in the whipping and the maiming of the Msoto residents by the ARPU agents violated the requirement of necessity and proportionality in the use of force, which, in accordance with Section 152G of the Land Act, is also a mandatory procedure which must be followed without fail by any person conducting an eviction. The requirement of necessity and proportionality in the use of force, was exemplified in the Court of Appeal case Inspector of Police Veronica Gitahi versus the Republic 2017, in which it affirmed the conditions as to the use of force and firearms by police agents. They stipulate that first, non-violent means should be effected before resorting to force. And secondly, when force is used, that force should be proportionate to the objective, the seriousness of the offense, the resistance of the person against whom it is used, and only to the extent that is necessary. As has been shown in paragraph 15 of the fact sheet, the whipping and the maiming of Msoto residents happened to any person the ARPU agents found in the Msoto area. It is not indicated that the Msoto residents were violent. It is not indicated that the Msoto residents were rowdy to such an extent to warrant that use of force. And therefore, it shows that there is a gross indifference on the part of the police agents to dignity and human life, and a violation of the requirement of necessity and the proportionality in the use of force. Now, counsel for the respondents may seek to claim that the actions of the ARPU agents are not attributable to the state, to which we assert and we bring to the attention to this court the cases of Uhuru Muigai Kenyatta versus the Nairobi Star publications reported in 2013 before the High Court of Nairobi, where the holding of Justice Isaac Lenaola was to the effect that it is the state and the state's organs' obligations to observe, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. No such obligation is placed on an individual. In the case of the Law Society, also more recently and more relevant to this case, in the case of Law Society of Kenya and three others versus the Attorney General and three others, reported in 2016 in the High Court of Kenya concerning the infamous enforced disappearance of Advocate Willie Kimani as well as his two colleagues. It was held that where it is clear to the court that the police hierarchy is acting in impunity and without regard to the rule of law and the supervisory jurisdiction of the courts and the oversight bodies such as IPOA, then it is the state that should be held liable and not the police, and it should be the state that should be held liable as well as the police officers who are found responsible. In this case, pursuant to paragraph 15 of the fact sheet, the ARPU agents are seen to be taking orders from a superior not to tolerate any form of engagement with the public. This shows that the police service hierarchy was indifferent to what those instructions mean to the Msoto residents, and therefore they should be held liable by extension. Having come to the close of my submissions, I will now cede the floor to my co-counsel if there are no questions from the bench.
Counsel, a question. I'll take you back to the issue of jurisdiction. You say that the High Court this court has jurisdiction to listen to this matter. I look at the Environment and the Land Court Act, gives the Environment and Land Court the jurisdiction to listen to matters relating to land, and the violations alleged to have taken place in this case emanate from the issue of land. So do you still hold that this court has jurisdiction to listen to this matter, or should it be taken to the Environment and Land Court?
Thank you, my lady. I will answer your question twofold. First, I will reiterate my position that in Section 13 of the Environment and Land Act, the jurisdiction of the Environment and Land Court is to determine any matters any dispute relating to land. In this case, there is no dispute relating to the land in issue. The land in issue the petitioners do assert that the land in issue, the proprietary rights and interest in the land in issue belong to the government, to the state, or belong to the people of Kenya by virtue of it being a road reserve and public land. However, we assert that there are some other rights that arise as a result of the evictions of the petitioners that cannot be properly before the jurisdiction of the Environment and Land Court, since the Environment and Land Court only has human rights jurisdiction to the extent of Articles 42, 69, and 70, which provide for the rights to a clean and healthy environment. The second way I could answer this question is to provide the numerous cases in which the High Court has established, in which the numerous cases which are substantially similar to this case, which include Ibrahim Sangor Osman versus the Minister of Provincial Security, Satrus Ayuma versus the registered trustees of the Kenya Railway Staff Retirement Benefit Scheme as established in 2015, where the facts were substantially similar to this case, yet the jurisdiction of this court was affirmed in the affirmative. Yet those issues concern evictions and land respectively. If I have answered your question sufficiently, I will now cede the floor to my co-counsel.
Greetings, members of the bench. My name is Nyangweso Gladys Ann, appearing as the second counsel on behalf of the petitioners. Of the 15 minutes granted to me by this court, I will use 8 minutes of this court's time to address the third issue in contention concerning the violation of the right to adequate and accessible housing, and the first issue in contention concerning the violation of the right of access to justice. If there are no directions from the bench, I will now proceed. The third issue in contention is whether failure by the government to compensate Msoto residents amounted to a violation of the right to adequate and accessible housing. It is indeed the petitioner's position that failure by the UMA government to compensate all Msoto residents amounted to a violation of the right to accessible and adequate housing and to reasonable standards of sanitation. This will be proven in two limbs. The first will be to establish that the government of UMA has an obligation towards the petitioners, and the second will be to establish that the government of UMA should have provided alternative accommodation to the Msoto residents. On to the first limb. The government of UMA has an obligation towards the petitioners. It is the petitioner's submission that the government of UMA has an obligation to fulfill their right to housing. Article 21(1) of the Constitution of UMA stipulates the tripartite typology of state obligations to protect, respect, and fulfill the rights of its citizens. And as is evidenced by paragraph 15 of the record, members of the bench, the government of UMA has already violated its obligation to respect and protect the rights of its citizens. And it was held in the High Court case of Ibrahim Sangor versus Minister of State, Provincial Security and Administration and Internal Security, reported in 2011 that the government of UMA, being a member of the government of UMA, having ratified the International Covenant on Social and Economic Rights, was under an obligation to fulfill the right to housing, more so if it was the cause of homelessness. Pursuant to paragraph 4 of the record, the government of UMA is the one that issued the eviction notice, and the demolition that happened on the 20th of June were done following this notice. Therefore, the government of UMA is the one that caused the homelessness of the Msoto residents, and as such, they have an obligation to fulfill their right to housing. It is imperative to note, members of the bench, that the Msoto residents aren't just any ordinary citizens. They are internally displaced persons, a vulnerable group. Article 25B of the Constitution of UMA requires the government, in allocating resources under Article 43, to consider the vulnerability and prevailing circumstances of particular groups. And further, Section 11(5)(f) of the Prevention, Protection, and Assistance to Internally Displaced Persons and Affected the Community places upon the government an obligation to ensure adequate provision of socio-economic rights specified in Article 43. And in the High Court case of Kefa Omondi Onjuro and others versus Attorney General and 5 others reported in 2015, it was stated that the government must make maximum use of its available resources to provide, especially for those who lack the capacity to provide for themselves. This case is relevant because, pursuant to paragraph 5 of the record, the Msoto residents lack property ownership and academic documents. As such, it will be very hard for them even to acquire property elsewhere. It is therefore the petitioner's submission that the government of UMA has an obligation to fulfill their right to housing, and this could be done through compensation, or better still, through alternative accommodation, which leads me to the second limb of my argument. The government of UMA should have provided alternative accommodation to the Msoto residents. It is the petitioner's assertion that the government of UMA should have provided alternative accommodation to the Msoto residents. Article 21(2) of the Constitution of UMA requires the state to undertake legislative and policy measures for the progressive realization of rights under Article 43. And it was stated in the High Court case of Republic versus Cabinet Secretary, Ministry of Transport and Infrastructure, ex parte Francis Kiforo and 198 others reported in 2015 that where the state permits people to live on a certain piece of land, whether government or private, for a long period of time, then it will be unjust for the government to evict them without affording them an opportunity to seek alternative housing. Members of the bench, after the eviction notice was issued, pursuant to paragraph 4, the evictions were done only 16 days after the notice was given. This was not adequate time for the Msoto residents to get other places to live. And it was held in the High Court case of Kefa Omondi Onjuru and others versus Attorney General and 5 others reported in 2015 that where people had developed businesses and residents in a particular place, then monetary compensation, members of the bench, would not suffice. And the government was under an obligation to reconstruct new residents for such people so as to restore their livelihood. Pursuant to paragraph 5 of the record, we see that the Msoto residents had developed informal trading businesses there. They worked as cleaners and security guards, and this was their place of living. Therefore, through their eviction, they lost their identity, their place of living. And as we can see, pursuant to paragraph 24 of the record, the government of Uma moved the Masponyo residents to houses whose prices had been subsidized for them. Members of the bench, this was discriminatory to the Msoto residents, a violation of Article 27 of the Constitution of Uma, and this goes to show that the government of Uma had the resources to ensure that it provided the Msoto residents with alternative accommodation. It is therefore the petitioner's assertion that the government of Uma should have provided the Msoto residents with alternative accommodation. On to the first issue in contention. The first issue in contention is whether failure by the Uma government to adhere to court orders was a violation of the right of access to justice provided for under Article 48 of the Constitution of Uma. It is the petitioner's averment that failure by the respondents to adhere to court orders did in fact violate the right of access to justice of the Msoto residents. It was held in the case of Hodgkinson versus Hodgkinson and affirmed in the High Court case of Kenya Tea Growers Association versus Francis Atwoli and 5 others reported in 2012 that there is a plain and unqualified obligation upon every person upon whom an order was made by a competent jurisdiction to obey that order unless and until that order is discharged. It therefore follows, members of the bench, that adherence to court orders is mandatory. The petitioner will seek to establish that the violation of the first court order led to the eventual demolition of the Msoto residence area and their homelessness, and the second limit will be to establish that the government of Uma violated the absolute right of habeas corpus by failing to adhere to the second court order. On to the first limb of my argument concerning the violation of the first court order, which led to the homelessness of the Msoto residents. It is the petitioner's position that the respondents intentionally violated the first court order, which led to the eviction and homelessness of the Msoto residents. It was established in the High Court case of Basil Criticus versus Attorney General and 12 others reported in 2012 that knowledge supersedes personal service. Therefore, members of the bench, where it is proven that a party has knowledge of an order, the strict requirement for personal service is rendered unnecessary. Pursuant to paragraph 4 of the record, the government of Uma issued the eviction notice. And as we can see, pursuant to paragraph 8, the Uma Human Rights Commission moved to court seeking a restraining order against the demolition, which was granted to them. And as is evidenced by paragraph 9, when the government brought in their machinery to start the demolition on the 16th of June, concerned officials were informed of the existence of an order. They are termed concerned because it is connoted that they have the power to ensure that the respondents, who are the Attorney General, the Minister for Lands and Physical Planning, and the Minister for Infrastructure, were informed of the existence of an order. Therefore, members of the bench, the actions of the respondents from the 16th of June to the 20th of June 2019 were with the knowledge of the existence of an order. It is therefore the respondent's submission, the petitioner's submission, that the respondents, having had knowledge of the existence of this order and went on to carry out the demolition process, this was really unfair to the Msoto residents, and the respondents should be held to be in contempt of court. On to the second limb of my argument concerning the violation of the second court order, which was a violation of the absolute right of habeas corpus. It is the petitioner's assertion that the violation of the second court order was a violation of the absolute right of habeas corpus, a violation of the right of access to justice, and a violation of the freedom and security of the person. Article 25D of the Constitution of UMA provides for the absolute right of habeas corpus. It is a non-derogable right, members of the bench, and it was further stated in the High Court case of Masood Salim Hamed and another versus Director of Public Prosecution and 3 others reported in 2014 that the right to habeas corpus cannot be limited, members of the bench. It was also stated in the High Court case of Miguna versus Fred Okengo Matiani, Cabinet Secretary, Ministry of Interior and Coordination of National Government, and 6 others, and the Kenya National Human Rights Commission as an interested party reported in 2018 that failure to produce a person in court within the recommended time was a violation of the absolute right of habeas corpus and freedom and security of the person, which are fundamental rights guaranteed by the Bill of Rights of the UMA Constitution. Pursuant to paragraph 26 of the record, the police arrested Msoto demonstrators for causing chaos during the demolition at Msoto. Only 3 were produced pursuant to paragraph 27, and as is evidenced by paragraph 28, the rest were being held incommunicado and being forced into a merged settlement. Members of the bench, it was not upon the respondents to decide whether to keep holding them Msoto residents or produce them in court. They should have produced them in court, as it is the mandate of the court to order either detention orders, to order either them Msoto residents to be further detained or to be released on bail. And the respondents may seek to claim that the petitioners did not have custody of the Msoto residents, but in the case of Velasquez Rodriguez versus Honduras, and affirmed in the case of Law Society of Kenya and 2 others versus Attorney General and 2 others, the elements of proving custody were stipulated, which are as follows. There has to be deprivation against the will of the person. This deprivation has to be effected by the state or its agents, and the failure by the state to acknowledge such detention. Pursuant to paragraph 26, the police arrested the Msoto residents, and they failed to even acknowledge this detention pursuant to paragraph 28. Basing on circumstantial evidence, this goes to show that the Msoto residents were indeed in police custody. And pursuant to paragraph 29, when the court order was issued in the presence of state law officers, the Inspector General of Police did not deny custody of the Msoto residents. This shows that they had them in their custody, but they just failed to produce them. It is therefore the petitioner's position that this was an intentional violation of the absolute right of habeas corpus, which should not be condoned by this court, because failure to adhere to court orders is a violation of the rule of law that entitles equality to all persons, pursuant to Article 10 of the Constitution of UMA. Having come to a close of my submission, I will now state the prayers. The petitioner prays from this court that a declaration be made that failure by the UMA government to adhere to court orders amounted to a violation of the right of access to justice, that this court finds that the actions of the police during the demolition process on the 20th of June amounted to a violation of the principle of due process of law, that a declaration be made that the failure by the UMA government to compensate Msoto residents was a violation of the right to accessible and adequate housing, and that the respondents be ordered to reconstruct new residents for the Msoto residents so as to restore their dignity and their livelihood. Thank you, members of the bench. If there are no questions from the bench, I will cede the floor to the opposing counsel.
Counsel,
I have a
if I
question.
may direct you, sorry. Yes.
You go
Madam
first.
Counsel, if I may direct you back to the issue of adequate housing, where them sort of people were given an opportunity to actually register for the compensation, but they opted not to. And the people who registered for the compensation were actually relocated. So why not the people of Lesotho could not have registered for the compensation and then now sat with the officials to maybe have a proper compensation that they felt was adequate.
Thank you, my lady. I will rely on paragraph 11 of the record, where the Minister of Transport and Infrastructure, in a press conference, gave the statement that the demolitions will be stalled to allow for further negotiations on a more amicable compensation. And I'll further rely on paragraph 8. There was a subsisting court order. The Msoto residents therefore thought that they could be accorded enough time to ensure that there was a good amicable scheme that was developed between them and the respondents. Therefore, that is why they did not register. They still thought that the negotiations will be ongoing to reach a solution that will be beneficial to both of them.
Council, did I get you to be saying that the government of UMA had an obligation to fulfill the right to accessible and adequate housing for the Msoto residents, irrespective of budgetary considerations and whether there was money? Are you saying the government had a duty to provide this, or it was something that was supposed to be progressively realized, being an economic and social right under the Constitution?
Thank you, my lady. I would like to request for 1 more minute to answer your question. I see that my time is spent.
Granted.
Okay, thank you, my lady. It is imperative to note that the Msoto residents are internally displaced persons, and I will rely again on the case of Kefa Omondi Onjuru and others versus Attorney General and 5 others, where it was stated that the state must make maximum use of its available resources to provide, especially for those who lack the capacity to provide for themselves, such as the Msoto residents. If the government could relocate the Masponyo residents to houses whose prices had been subsidized for them, then they could have accorded the same treatment to the Msoto residents.
Any other questions from the bench?
Yes. Question. You have submitted them very ably on the question of access to justice and alleged that the government of UMA is in flagrant contempt of the court orders to its face. Now, do you therefore expect that they have a right of audience and the benefit of the court's orders?
Sorry, my lord, could you please repeat the question? I didn't get it quite correctly.
Yes, I'm saying in view of the respondents' alleged contempt of court, do they have a right of audience and also a right of the benefits of the order of the court?
Thank you, my lord. I will reply relying on the case of Clerk of Nairobi City Council Assembly versus Speaker of Nairobi City Council Assembly and another, and the Orange Democratic Party and 4 others, reported in 2019, where it was stated that after the nullification of the Contempt of Court Act, then people could approach the court pursuant to Section 5 of the Judicature Act and have their matters listened to. So therefore, the respondents have a right to approach the bench to determine whether they actually violated these orders, which is the petitioner's assertion that they did.
Thank you.
Thank you very much. Before we move to the respondent's case, I would like to inform you that unfortunately, Judge Wangila Waliula has had to leave the court because of technological challenges, and that was with the permission of the court. And we've been joined by Judge Victor Kamau, whom I will just request to briefly introduce himself before we carry on. He joined us earlier.
Thank you, Madam Presiding Judge. My name is Victor Kamau. I'm a judge in Nismut, and I work for the Kenya National Commission on Human Rights.
Thank you very much. So we will go to the respondent's case unless there's any other question. Thank you. Team 805. It is now your time to present your case. Team 805.
Thank you, Madam President. Madam President, Your Honors, may it please the court. My name is Vera Cherotich, counsel for the respondent in this matter. In the 30 minutes time allocated to us by this court, I shall use the first 20 minutes to offer submissions on jurisdiction and admissibility, the first issue, where we assert that the government did not fail to adhere to court orders, therefore did not violate the right to access to justice of the Msoto residents. And the second issue, where we equally assert that in carrying out the demolition process, the government followed the due process of law. With regards to jurisdiction and admissibility, counsel submits that this court, pursuant to Article 165(3)(b), has been conferred the jurisdiction to listen to this matter as it pertains to the violation of the rights and fundamental human rights of the people of Uma. This is equally pursuant to Article 23(1) of the Constitution of Uma. The matter before this court is equally admissible as they pertain to the violations of rights and fundamental freedoms of the people of Msoto as they arise from the forced evictions. If the bench has no further questions, I'd like to proceed to the first issue.
Go ahead.
With regards to the first issue, counsel submits that the government did not fail to adhere to court orders, therefore cannot be found to be in violation of the right to access justice of the Msoto residents. The court orders I'm referring to in this matter are the restraining order and the order of habeas corpus. Counsel submits that the government, pursuant to the statement of facts, paragraph 9 and paragraph 29, they were not served with the said court orders. The Government Proceedings Act, Section 13, stipulates that with regards to all proceedings pertaining to the government, where it is required that the government to act in any way, the orders or the court processes need to be served to the government, to the Attorney General, pardon, Your Excellencies, to the Attorney General. That was not the case. The government was not served with the said court orders. The petitioners in this case have submitted the case of Basil Criticus versus the Attorney General held at the High Court of Kenya in the year 2012, where Justice Lenaola asserted that knowledge supersedes service. However, the facts can be distinguished in this case. In that case, Justice Lenaola went ahead to assert that knowledge supersedes service because he was duly satisfied that the petitioners in that case had made it possible for the respondents to be in the know of the said court orders. Justice Lenaola was satisfied that the petitioners published the said court orders in print media that has nationwide circulation, and this was made more than once. The petitioners equally in that case submitted before the court affidavits of news cuttings showing that they indeed published the court orders in print media, and therefore the government ought to have been in the know of the said court orders. In this case, however, Your Honors, that was not the case. The petitioners did not publish the said court orders in any newspaper that has nationwide circulation in the country of Uma, and therefore they cannot claim that the government was indeed in the know of the said court orders and expected the government to obey court orders that they were not served, Your Honors. With regards to the order of habeas corpus, Your Honor, counsel submits that the petitioners have duly asserted before this court that with regards to the writ of habeas corpus, custody is of necessity. Pursuant to paragraph 27, the respondents brought to court those whom they had in custody, Your Honors. The 3 Msoto residents that they had in custody, they were brought before court. And Your Honor, Council submits that at that time, those were the sort of residents that the government had in custody and duly obeyed the order of habeas corpus and brought those whom they had in custody to court. Even though the applicants might state that the respondents eventually produce them sort of residents in court at paragraph 30, we would like to concede before this court that we may have failed to seek the permission of the court to hold the sort of residence for more than 24 hours as is stipulated in the Constitution of UMA, but we did not fail to adhere to the order of habeas corpus, as we indeed complied with the order of habeas corpus and brought the people that the court wanted to court. The writ of habeas corpus is one that requires the government or the person that it has been ordered to produce the bodies of the said people, dead or alive, in court. Council submits that we produced them sort of residents in court. If the bench has no further questions or interjections, I'd like to proceed to the second issue.
How many people were taken into custody and how many were produced pursuant to the order made by the court?
Thank you, my lady. Pursuant to the statement of relevant facts, it is not clear how many people were arrested, Your Honor. The facts just state that there were arrests made. There were arrests made, and when the government when it came to producing them in court, the government produced them sort of residents they had in custody in court, my lady.
So your position is that it was only 3 who were arrested and they were produced pursuant to the court order?
The fact states, sorry, my lady, pursuant to the statement of fact, the number of people who were arrested is not clear, but the ones who we produced in court, whom we had in custody, are 3 Msoto residents, my lady.
Thank you.
If the bench has no further questions, I'd like to address the court with regards to the second issue. With regards to the second issue, Council submits that in carrying out the said demolitions, the government indeed followed the due process of law. Council submits that the Land Laws Amendment Act of 2016 of the Republic of Kenya stipulates the requirements to be followed during evictions. This is pursuant to Section 98, subsection 152G of that said Act, Your Honor. The following requirements are to be met by the government as in carrying out this, the evictions. 1, that there needs to be formal identification. 2, that there needs to be formal authorization. And where there are groups of people, there needs to be government representatives during the carrying out of the said evictions. And 3, that while carrying out the said evictions, the manner in which the evictions are carried out, they should be in a manner that respects the right to life, right to dignity, and the security of the persons affected. And 4, in the event that the people carrying out the evictions resort to the use of force, it should pay due regard to the principle of necessity and the principle of proportionality. Council submits that the government indeed met these 4 requirements while carrying out the said demolitions, Your Honors. There was formal identification. This is pursuant to the statement of facts, paragraph 4. The National Land Commission, the Minister in charge of Housing, the Minister in charge of Transport and Infrastructure, these were all people who had been identified that would take part in carrying out the said eviction. So there was formal identification. There was formal authorization, since this matter had been has been determined in a court of law, and the judge in that court determined that the government had a right to carry out the said demolitions as there was a public interest of overriding the interest of the Msoto residents. The public interest in this case was that there was going to be a construction of a road, Your Honor. And let it be known that this land that the Msoto residents were living on was a road reserve indeed. So therefore, the government actually made the requirement of having formal authorization as they were given a go-ahead by the court, as this was due to the issue of public interest. With regards to the right to life, right to dignity, and right to the security of the persons affected to be respected while carrying out the said demolitions, Council submits that the government followed also adhered to this requirement. It is only that one rogue officer who is seen to manhandle the elderly lady and the young man during the said evictions, Your Honor. Council submits that the government indeed took into action the outcry that had been made by the Msoto residents, and that rogue police officer was indeed suspended, and the government is carrying out investigations with regards to that manner of police brutality. It is the respondent's position that the government does not condone police brutality, and it is in its mandate and its core mandate indeed that they will ensure the security of the people of Uma, and therefore police brutality will be the officers found in this police brutality will receive the full arm of the law, as the government does not condone this behavior. That's why we can see at paragraph 21 of the statement of facts, the rogue police officer was indeed suspended. With regards to the use of force and meeting the principle of necessity and proportionality, Council submits that this requirement was also met by the government. Council submits that during the evictions, as the evictions were taking place, the Msoto residents started becoming agitated and started throwing and destroying the government machinery. Some of them were even seen to be wearing combat paraphernalia, which is contrary to the law of Uma, Your Honor. This was, in a sense, trying to show that they were almost in a position to start war with the government of Uma, and this is not what the government of Uma wanted to happen in that during the eviction. That's why the force in which that the Msoto residents used in destroying the government machinery, the government was also trying to protect its machinery and at the same time protect other residents of Msoto. The government could not afford to have other residents of Msoto being harmed during this said evictions just because we had some residents demonstrating and acting in a manner that trying to destroy government machinery, and this would have even harmed other Msoto residents. The respondent submits that the protection of even one person is something that the government needed to do, because one person, if one person was hurt in that eviction, one person is one too many for the government, Your Honors. Council submits that the government indeed, as I've listed the requirements that are to be followed in the first eviction, in first evictions pursuant to the Land Amendment Act of 2016, and section 98 and subsection 152G, that the government indeed fulfilled all those requirements and therefore should be found to have followed the due process of law while carrying out the said demolitions. Council would like to respond to what the applicant stated with regards to adequate prior notice. Council submits that with regards to the Land Act of 2012, section 155(4), Council submits that in determining whether to serve a notice, oral or a notice or an oral communication, and the period of time to be specified in the notice by the end of which the person is required to vacate the land, and the Commission shall take account of the following requirements. This section 155 of the Land Act talks of unlawful occupation of land. Council submits that the applicants in this case were unlawful occupants of the land. The land was a public road, the land was a public land, and it was a road reserve. Therefore, the government took into account these requirements under section 155(4) of the Land Act while issuing the notice and the period of time to vacate the land.
So, a question. Yes. Pursuant to paragraph 5, these Soto residents are deemed as internally displaced people. Are there any specific obligations that the government owed these people as IDPs, and were these obligations fulfilled, or are there any steps that were made towards fulfillment of those obligations?
Thank you, my lady, for your question. The council duly agrees that the Msoto residents were internally displaced persons, and they were victims of the 2007 and 2008 post-election violence. However, council submits that they resided on public land, which was a road reserve. It is also the respondent's position that the right to adequate and accessible housing is a progressive realization right. The government, while carrying out the said demolitions, conducted meaningful engagements with the Msoto residents and asked them to register for compensation so that they can be duly resettled, so that they can be able to resettle elsewhere so they can be able to resettle elsewhere, as the government was duly in the know of its mandate to ensure that the Msoto residents are enjoy the right to adequate and accessible housing. Council submits that the right to adequate and accessible housing is a progressive realization right, and it is not an immediate realization right. The government should be accorded a wide margin of appreciation as it makes steps to ensure that this right is duly enjoyed, my lady.
Further clarification, seeing that the residents of formerly Masponyo were relocated or resettled or given subsidized housing, why couldn't the same be accorded to Msoto residents? And also, while you answer that, I would wish that you make reference to section 9.2 of the Prevention, Protection and Assistance to IDPs and Affected Communities Act, where the government has the obligation to give durable and sustainable solutions in instances of internally displaced persons. Are there any steps since 2008 that the government took towards resettlement of the Msoto residents?
Thank you, my lady, for your question. Seeing that my time is almost spent, my lady, and your question is well within the purview of my co-counsel submission, I'd like to request my lady to allow my co-counsel to respond to that question. So as I conclude on this issue, my lady.
I have a question for you. You referred to section 155 and said they were unlawfully occupying public land, but that was passed in 2012. Then in 2016, amendments to the Land Act requires 152, I think, C, requires that if it is public land that is unlawfully occupied, and they needed to have 3 months notice, that is 90 days. And so in this case, what period of notice did you give the Msoto residents before evicting them?
Thank you, my lady, for your question. Pursuant to the statement of relevant facts, the government issued an 11-day notice to the people of Msoto, and after that, it accorded them a 4 days period for meaningful engagement, Your Honor, pursuant to paragraph 10 of the statement of relevant facts, Your Honor. And also pursuant to paragraph 24 of the statement of relevant facts, the demolitions were not carried out until the government added the Msoto residents 14 days to relocate, Your Honor. Therefore, the government finds in it to their minds that they gave adequate prior notice to the Msoto residents before carrying out the said demolitions, my lady. Seeing that my time is far much spent, Your Honor, I'd like to conclude on my submissions before I yield the floor to my co-counsel. Council will therefore submit that the government, in carrying out the said demolition process, indeed follow the due process of law pursuant to the Land Laws Amendment Act of 2016, Section 98, subsection 152G, and we fulfilled all the requirements as I had stated, that we gave formal identification, formal authorization, the evictions are carried out in a manner that respected the right to life, right to dignity, and the right to security of affected persons, and that the force that was used indeed paid due regard to the principle of necessity and proportionality. We also submit before this court that the respondents did not fail to adhere to court orders, and therefore the said demolitions that were carried out did not violate the right to access to justice of Msoto residents. If the bench has no further questions, I'd like to yield the floor to my co-counsel.
Thank you very much. Anybody else with a question, members of the bench? No questions? Thank you. She can proceed, council can proceed.
Madam President, Your Excellencies, may it please the court, my name is Laura Otieno, co-counsel to the respondent, and I shall be using 10 minutes to address the court on issue 3 and give prayers for the respondent. With regards to the third issue, it is the respondent's case that the government did not violate the rights under Article 43(1)(b) of the Constitution. In seeking to persuade this court, the respondent tenders the following arguments. 1, that the state has no obligation to compensate unlawful occupants of land. 2, that the right of housing can be justifiably be limited. And 3, that the government indeed took measures to ensure that Msoto residents signed up for compensation, but those who failed to sign up for compensation are the ones who did not get the compensation. If this court has no questions or clarifications, I'd like to proceed to my arguments.
Yes. Question. Council, since you're saying that the government is not obliged to compensate, what was the basis on which, therefore, they compensated those that they compensated?
Your Honor, it is the respondent's submission that the government issued this compensation on the basis that Msoto residents are internally displaced persons and not that they occupied public land. And therefore, the government in its mandate to ensure that the right under Article 43(1)(b) of the Constitution is enjoyed by Msoto residents compensated those who registered. And those who failed to register are the ones who are not enjoying the right under Article 43(1)(b) of the Constitution.
So a further
Thank you. Okay.
A further clarification on the submission. You say that the ones who failed to register were not accorded the compensation, but those who failed to register allege that they were not given an opportunity for consultation, proper consultation, and that is why they could not proceed to register for the compensation. What would you say about that?
Your Honor, pursuant to paragraph 14, the government sent officers to engage meaningfully with the Msoto residents. And the proposals given by the Msoto residents were forwarded to the Interministerial Committee and were considered. And therefore, the government meaningfully engaged with the Msoto residents and compensated those who signed up for compensation.
Okay.
Your Honor, it is the respondent's submission that the right under Article 43(1)(b) of the Constitution can be justifiably be limited. Article 24 of the Constitution provides for the limitation of rights and fundamental freedoms in the Bill of Rights. It lays out a conjunctive test, setting out requirements that should be met by the government while limiting rights. The first requirement is that the limitation should be provided for by the law. It is the respondent's submission that under Article 25 of the Constitution, it provides the rights that cannot be limited, and the right under Article 43 is not one of them. And therefore, the government met this test. The second test is that the limitation should be reasonable and justifiable. Your Honor, pursuant to paragraph 7 of the fact sheet, all those who are subject to the notice of evacuation were living on a road reserve. And therefore, the government was justified in demolishing the houses for Msoto residents as the said land was a public land and they do not have any interest in that land. And therefore, the government, if anything, considered the interest of a larger public in demolishing the houses because the road was for a development agenda that will not only benefit Msoto residents, but Uma citizens. The third test is the test of proportionality, requiring the government to adopt a less restrictive means. Your Honor, it is the respondent's case that the government adopted as less restrictive means. Your Honor, the applicants might claim that the government failed to consider the proposal that was offered by Umoja Wetu. It is the respondent's case that this proposal that was offered by Umoja Wetu was a more expensive alternative, and therefore the government could not exploit such an alternative, given that it had already set a public road for the purposes of construction of this road, and therefore the government met the test of proportionality. Your Honor, it is the respondent's case that the government indeed is aware of its obligation to fulfill and respect the right under Article 43(1)(b) of the Constitution. Article 21(2) of the Constitution requires the government to put in mechanisms to progressively realize the rights under Article 43. It is the respondent's submission that the government did indeed put mechanisms to ensure that Msoto residents are compensated. Excuse me. Your Honor, the respondents called for compensation, but Msoto residents failed to sign up for the same, and therefore they cannot claim that their rights were violated since they failed to sign up for compensation. It should be noted that those who signed up for compensation were duly compensated. Masponyo residents, the government subsidized the housings, and for Msoto residents, the government offered compensatory amounts, and therefore the government ensured the maximum resources are availed, since compensation can take various forms. It is the respondent's submission that those who failed to sign up are the ones who are compensated. And 1 year down the line, those who are compensated have not complained, and therefore the compensation amounts offered by the government were indeed adequate, Your Honor. Your Honor, would also like to bring to the attention of this court that there is progressive realization of rights, and this is subject to availability of resources. Your Honor, it is therefore the respondent's case that the government fully engaged all the resources that are available within its means to ensure that this right is enjoyed. Your Honor, in the case of Kepa Omondi Onjuro and others versus the Attorney General, it sets the precedent to ensure that all those who claim for resettlement are required to register. And therefore, in this case, the High Court held that those who failed to register for compensation are not entitled to any form of compensation, as they are illegal occupants. And therefore, it is the respondent's case that everyone who was required to sign up for compensation was duly compensated, and those who did not register are the ones who are complaining.
I am troubled that you will be dealing with a case of recurrence of IDPs, because there is a group of people who refused compensation because they thought meaningful consultations was not done. They are still on the road reserves. They are going to be displaced again and again. Has the government done anything to offer durable and sustainable solutions to this IDP issue, because they owe an obligation to the IDPs for durable and sustainable solutions to their problem?
Your Honor, it is the respondent's submission that those who signed up have not complained. They were given compensatory amounts and therefore resettled elsewhere. And therefore, those who claim that they were not compensated and are still living in tents are the ones who failed to register for the same. And therefore, the government should not be faulted for not compensating those who registered, because it compensated all those who registered. Embracing it in its mandates to embracing the mandate of progressive realization of rights. Your Honor, it should be noted that those who failed to register cited the amounts that were offered by government as very little and impractical. Your Honor, it is the government's mandate within its available resources to ensure that the right under under Article 43(1)(b) is enjoyed. And therefore, the government employed maximum resources to ensure that this right is enjoyed, Your Honor.
Well, again, Council, compensation does not necessarily have to be monetary, or rather IDPs can be compensated or resettled. In the quest to resettle these IDPs who had lost their documentations of land ownership and education that would subsequently give them employment, did the government take any steps, at least to enable them reconstruct the documents of the land ownership or documents that would enable them access employment, because the government owes that to the IDPs?
And Council, in furtherance to that, I believe the government has a mandate, even in the eviction process, not to render individuals homeless and vulnerable to violation of other human rights. So I think you should tell us what the state is actually doing to ensure that those people have not been rendered homeless, just despite that they didn't find the compensation worthwhile. So yes.
Your Honor, it is the respondent's submission that the demolition process that was carried out rendered Msoto residents homeless, and the government proposed a compensation plan to ensure this is not the case. And those who signed up were compensated. Those who failed to sign up are the ones who are decrying of homelessness. It should also be noted that UMA is a third world country, and it has experienced a growth of 2.3% in the last 5 years. And its economic state has been contributed by the numerous political coups that has been witnessed in the country. And therefore, the court should see that the government employed the maximum resources available at its disposal to ensure that the case of homelessness is not happening. But those who failed to sign up for the same are the ones who are decrying that their rights were not fulfilled. Your Honor, if this court has no questions, I would like to proceed to the prayers for the respondent.
Go ahead.
Your Honor, in light of the submission given by my co-counsel and I, we would urge this court to find that the government did not violate the right under Article 43(1)(b) of the Constitution, because it compensated all those who duly signed up for the compensation. And that two, a declaration that the government followed the due process of law while in the demolition process carried out on the 20th June 2019. And three, that the government did not violate the right of access to justice, for it duly followed the court orders that were given by the courts.
A clarification, Council, sorry, a clarification. What would be the eventual fate of these people who are still on the road reserves? Are they going to be kicked out of the country eventually because they do not own any land and they are not agreeable to the compensation given by the government?
Your Honor, the fate of those who are still living in tents along the construction zone, it has been noted by the state that they are still living there, and it is the state prayer that after the construction of this major road, that there will be economic progress and that the government will further avail resources to ensure that they are resettled and that they have property ownership documents, Your Honor. And therefore, this will not be the case in the next few years to come.
Very well. I hope it's not going to be another decade, because they've already waited a decade.
Yes, certainly, Your Honor. Thank you,
Yes.
Your Honors.
A question. Now, your prayers were for certain declarations and so on. But what do you then want to happen to the petition?
Kindly repeat the question.
What do you want us, the court, to do with the petition?
To offer orders as they may duly fit, Your Honor, and declare that the government did not violate any rights as the applicants are trying to urge this court to find.
Thank you very much. Have you finished, Counsel?
Yes, thank you, Your Honor. If this court has no further questions or clarifications, I would like to thank you for your time.
Thank you very much. The petitioners, do you have anything to say? Or do you want to leave it to
Yes.
the court? Thank you.
Yes, my lady. I have a few rebuttals based on the 3 minutes that have been accorded to me by the court.
Thank you. Go ahead, Mr. Gitau.
Thank you, my lady. I will first of all begin by rebutting the first assertion, the assertion of the first opposing counsel on the fact that there was that the respondents did not have custody of the sort of demonstrators that were missing in custody. It is the petitioner's submission that circumstantial evidence is to the effect that the respondents had custody of the sort of demonstrators in question. Circumstantial evidence was defined in the case of LA Law Society of Kenya and 2 others versus the Attorney General and 3 others reported in 2016 concerning the infamous enforced disappearance of Willie Kimani. To circumstantial evidence includes circumstantial evidence is evidence to prove or to the extent that it leaves no doubt that the claims asserted by a certain person are true or false. Therefore, in this case, circumstantial evidence is to the favor of the petitioners that the respondents did in fact have custody of them sort of demonstrators. I will start off by showing that the sort of demonstrators that were missing were arrested in the company of the 3 persons who are produced in court. Secondly, it has been stated in the fact sheet in accordance with paragraph 28 that they were being held incommunicado and being forced into a merged settlement. Thirdly, the fact that they were eventually produced in court by the respondents. And fourthly, the fact that the inspector of police did not dispute custody. This shows that custody has been proved to be the burden of custody that is generally on the part of the petitioners has been dispensed of through circumstantial evidence. On to the second rebuttal concerning the actions of the ARPU agents being justified due to the fact that the Msoto residents were in combat paraphernalia and they had destroyed property in the Masponyo estate. It is the petitioner's assertion that firstly, the whipping and maiming of the Msoto residents happened before the Msoto demonstrators invaded the Masponyo area to loot property, and therefore it cannot be used as a justification. Secondly, I would like to refer to the case of Republic versus Cabinet Secretary for Transport and Infrastructure, ex parte Francis N. Kiforo, reported in 2014, where it was stated by the Honorable Judge that it is the duty of the state to bridge the gap between the haves and have-nots, so that the people, the vulnerable people, or the persons who are in poverty do not find it necessary to eke a living from people who have more means. In this case, the government has shown a complete disregard of the Msoto residents. They have detained them, they have whipped them, and they have maimed them. In all senses of the word, the respondents have antagonized the Msoto residents, and therefore the respondents cannot seek again to place blame on the Msoto residents for having looted and pillaged the Masponyo estate, though it is our assertion that that is wrong. Which brings me to the third and final. I realize that my time is far much spent. I will now cede the floor to my judges to make the determination.
Thank you very much. The respondents, Do you wish to make your rebuttals?
Yes.
Or you want to leave it to the court?
Yes, Madam President.
Go ahead.
Thank you, Madam President. I'd like to request this court for 3 minutes to offer our rebuttals. Madam President, the opposing counsel has stated before this court that the evidence that they were relying on was circumstantial evidence to note that there were the total residents were arrested and the ones that they were not produced in court. The counsel is relying on circumstantial evidence, and we would like to bring to submit before this court that we are relying on direct evidence, my lady, your honors. The direct evidence pursuant to the statement of facts is that the Msoto residents who were arrested and duly produced in court were 3 Msoto residents, your honors. And they're the ones that we obeyed the order of habeas corpus that was issued, and therefore the residents were produced in court as requested by the court, your honor. We submit before this court that your honors should pay due regard to direct evidence that we submit before this court that takes precedence over circumstantial evidence when it comes to the rules of evidence, your honors. Counsel submits that the opposing counsel has duly admitted that their clients looted the properties of the respondents, your honor. Their clients destroyed the machineries of the government, your honor. That this should be taken into account, that the force that was being used to rebut what the social residents are doing, then should be found to be proportional, since the applicants themselves are duly submitting before this court that they indeed looted the properties of the respondents, your honor. We pray that this court finds that the force that was used during the evictions was therefore indeed proportionate to the force that the social residents meted upon the government by destroying their property and going further ahead to dress like in combat paraphernalia, your honor. We also duly pray that this court finds that the government duly obeyed the order of habeas corpus due to the direct evidence we submit before this court that those who were arrested, the 3 social residents, were duly brought before court, your honors. Thank you, your honors.
Thank you very much. I believe the court will withdraw to consider the submissions, and the court bailiff can give us directions on who should exit the court and how they will do that, so that we can have our deliberations. Court bailiff, please guide.
Very well. Thank you, presiding judge. Participants kindly exit. Then we only remain with the judges. So participants kindly exit. Thank you.
Thank you very much, members of the bench. At this point, Court bailiff, how much time do we have?
I think you can just make deliberations. Maybe okay, it's supposed to end at 1. So you have 17 more minutes for you to make deliberations and send the score sheets to the Akmcc email account.
Yes, may I hear from you?
Yes, I think it's been a very good, it's even an improvement from yesterday. I think we shall be sending the score sheets in good time.
And we are all clear on the parameters for the scoring?
I beg your pardon?
We are all clear on the parameters for scoring. We got
I
oral
think so.
solution.
We've got yes,
Okay.
and unless anyone has a query.
I just need to mute this because I need to take a call.